The public interest litigation field encompasses a diverse array of claims related to the defense of human rights. These claims often revolve around climate change, biodiversity, natural resource conservation, and pollution. Pollution-related cases extend to issues such as mining, pesticide usage, and plastic pollution. Additionally, within this field, there are social claims addressing social rights, labor safety, inclusion, and discrimination. Governance claims, on the other hand, touch upon matters like corruption, breaches of fiduciary duty, and greenwashing. In the Netherlands, the Public Interest Litigation Project was initiated in 2014. Its purpose is to take a strategic action through litigation in cases where dialogue and lobbying prove ineffective on their own. The project handles cases related to refugees and migration, discrimination, law and democracy, as well as social rights. Despite the efforts of numerous associations supporting citizens' human rights, access to justice is not always straightforward. For decades, during the expansion of welfare policies, public legal aid programs were pillars of support for those without financial means. They ensured equitable access to justice and legal representation. However, in recent times, a shift has occurred. Public legal aid programs faced resource constraints and budget reductions, leading to reduced coverage. This shift has resulted in a widening gap in access to justice. Those with financial resources may find it easier to exercise their rights, while others may face the challenge of navigating the legal system without support. In the pursuit of a more equitable system, innovative solutions are emerging to bridge the gap, restore balance, and ensure that justice is not merely a privilege, but a right for all. Private actors are now involved in promoting human rights in the realm of access to justice, while also engaging in environmental, social, and governance investment. This approach reshapes investing, focusing on companies that generate profits while contributing to a better world. One of the first alternatives developed to fulfill access to justice in recent decades is third-party litigation funding, or simply TPLF. This financial arrangement involves an external party, distinct from the plaintiff and their attorney, providing funding for a lawsuit in exchange for a portion of the potential recovery. In this arrangement, the litigation funder assumes the financial risk associated with the lawsuit. One of the significant advantages of third-party litigation funding is its role in enhancing access to justice. It levels the playing field, allowing individuals and organizations with valid legal claims to pursue their cases without being hindered by financial constraints. Nivalian is a key player in this innovative field, with a substantial portfolio of cases. They dedicate 28% of their portfolio to direct and indirect ESG cases, where 45% is represented by the finance of environmental cases, 33% to social cases, and 22% to governance claims. Focusing on the governance elements of ESG, restitution seeks to leverage the tools of capitalism against bad actors to clean up the system by combating wrongdoing for the greater social good. Restitution strives to rebalance the playing field by returning power to the people, fighting corruption, and ensuring that recovered assets are used for the greater social good. Another actor in the litigation finance scene is Lex Capital, a benefit corporation dedicated to simplifying access to justice. They assess, acquire, and manage claims with an altruistic perspective. Through their technology, they streamline the legal process, making justice accessible and efficient. While we may hope that all these novel improvements will work for the best, there are critical points to consider. In a world where profit and justice intersect, what safeguards can be implemented to ensure transparency, accountability, and the pursuit of ethical outcomes? How can organizations like Nivalion, Restitution, and Lex Capital continue to empower justice while addressing concerns about conflicts of interest and unintended consequences? Could funders fulfill human rights objectives while collaborating with public interest associations? These questions signal the beginning of an enriching dialogue with the key actors. So, welcome to our living room and to the discussion open to finding new ideas to work for a more just and equitable world. As Louis Armstrong used to say, where altruism and business work together hand in hand. But is this really the case? Can really capitalism work for the good? This is naturally the overarching question that we are going to tackle today. But also, we are going to try to give answers to other questions related to the possibility of businesses to deal with non-profit causes and how these business models could potentially be interested in public interest litigation cases. Of course, we are not going to forget about a critical point of view. So without taking more time from the debate, I will introduce our guest discussers. Jelle Klaas is a human rights lawyer and executive director at PILP, so Public Interest Litigation Project, a law firm and NGO dedicated to strategic litigation and movement lawyering in the field of human rights in the Netherlands. So welcome, Jelle. Magdalena Tulivaca is a distinguished scholar specializing in European, international, and comparative law and policy, and she currently serves as a visiting assistant professor of practice at Emory University School of Law in the United States of America. So welcome, Magdalena. We are also having, of course, we have the complete bios in the program, so I'm just shortening them. And Thomas Kohlmeier, founded in 2016 Nivalion. He is the CEO of the company, a leading company active in litigation finance. And he is responsible of risk management and public policy matters within the company. So again, welcome, Thomas. Thank you. And Catherine Muller, she is the founder and CEO of Restitution. Restitution is an organization based in the UK and dedicated to assisting democratic, anti-corruption focused governments in their fight against corruption by providing funding and support for civil enforcement and asset recovery. Welcome, Catherine. Thank you for being here. And last but not least, Giuseppe Falcione. He's coming from Italy. He's the Chief Operating Officer at Lex Capital. Lex Capital is organized as a benefit corporation engaged in the finance of access to justice. His expertise extends to managing private equity venture, capital-backed companies, and publicly listed firms. Welcome, Giuseppe. Thank you for joining us in the discussion. So, of course, we are going to start with an interesting question about the overarching topic, right? How capitalism can potentially work for the good. But we are going to precise and say, shall investors support good causes? And because we already know something, I would refine it a little bit more. And I would say, how are you already doing this? So I will be passing the mic between all of us, and I would like to start with Thomas, who is kind of the starter of this.
Thank you. Hello. So when I was preparing for the conference, that was nice because the team at Nivalion had a strategic project at the same time, young members of the teams advocating that we should do more ESG cases. And I was scratching my head and said, I'm not believing in that kind of business because I see reputational risks, because I simply cannot see that we are funding this Peruvian farmer in his claim against the German government or RWE and taking away, say, 30% of his awards. So that doesn't make sense commercially. But then my team educated me and said, hey, but look what we are doing already, and Carlota, you showed the figures. Actually, what most funders are doing, and I think this is not germane to Nivalion, the industry started out on a David versus Goliath kind of playing field anyway. So we were typically funding smaller corporations against the big bad guys. Let me give you an example of cases that we're doing in the field of intellectual property. We are funding a company that is, and that's a typically ESG case we are doing, that has the patent to an invention that might change all of our behavior, because they invented cables that indicate when the current is flowing. So you're not forgetting to turn it off so you can save energy. Very simple mechanism with an enormous impact, labeled by Time magazine as one of the 50 most important innovations of current times. And that patent was stolen by some Chinese product pirates, and the company was trying to develop the US as a market, and the stolen products have been heavily marketed via the likes of Walmart and Amazon, so you had to sue companies like Amazon or Walmart, which would be impossible without funding. So that should give you a short overview of what we are doing.
Yes, and I would like also to ask Catherine to share her approach to using the tools of capitalism for doing the good, because that is your slogan, right?
Yeah, it is. It's really funny. It's also from some of the younger members of the team. So in many ways, Thomas and I have discussed this before. Restitution is almost the next wave of litigation funders, and it's not just us. There are impact litigation funders, and there was a question earlier about impact and also donors and others getting involved. And we do that. We have a very particular focus, but there are other impact litigation funders who essentially are doing environmental and social justice cases. There's one now which is very interesting, which would be worth looking at. So there are Brazilian farmers who are suing 2 large mining companies, and they've just passed jurisdictional hurdle in the UK, and it's a $30 billion claim. So potentially it could put both of those majors out of business or into some major restructuring. So that's the next wave of sort of environmental and social impact litigation. It's very large. It does have an impact in terms of behavior and corporate behavior. Our particular focus is 7 founders came together who are development and human rights specialists, as well as lawyers and investigators and finance people. And essentially all of us have worked with what I'll define very loosely as newly democratic post-conflict governments, often in the global south. And all of us had done work with those governments, and all of us were finding that these governments were being just ripped off over and over again. As we know, illicit financial flows are about $2 trillion per annum. And what we've done is we've used litigation funding models, but we've created an ESG approach where we work end-to-end with these governments, including developing the claims, providing capacity building and support for the governments, but also working with them to make sure the money isn't re-corrupted. So we can work with them in terms of setting up impact funds, environmental funds, sovereign wealth or stabilization funds. And what we're doing is essentially looking at G, and we're starting to monetize or value the G in ESG. So the delta between bad actors, what they should be doing and what they are doing, we're starting to look at that and actually start to value that. It's almost like it's a corruption premium we're starting to see. So we're starting to drive the market in terms of getting to some of these targets and saying, actually, you guys need to start changing your behavior as well. So it has potentially a global impact. And it's not just us, there are others who are doing it. But we see this as the next wave of ESG. So values driven, but also very much driven around the numbers, right? What are the deltas in terms of G? How do you potentially monetize this and return most of the assets to these governments, but also work with them to make sure you break the cycle of corruption?
Thank you. Point of view about the chance that this could be extended and be effective.
Yeah, so as
briefly, of course, if possible.
Yeah, I haven't even started, so but
no, but I know the critics can be big.
Not only critics, by the way, but that's not the point. I think as a human rights organization, we do cases against ethnic profiling, racism. We help the Roma Sinti travelers community, climate justice activists. I think from the perspective of our clients, I think that's one of the points that we want to take as a starting point. What does the movement want? What do the communities want? Talking about the goods of capitalism and the good points and the good causes, it would be very difficult to say anything positive for me about that, and I will not be going into that discussion. Don't tempt me that I also have colleagues in the room, and then I will take up too much time. I do think there is a space probably for individual capitalist investors when we talk about consumer cases against big capital trying to hurt them where it hurts, in their wallets or in their reputation. So I can think of a few cases where that could very be plausible and maybe interesting, but I'm very skeptical because I think when human rights are involved, having someone at the table that wants money and that is their main interest cuts away a lot of the options that you might also achieve with the case. And you start with, why are we doing litigation instead of protesting or lobbying? A litigation funder wants you to litigate. That's their model of earning money. And then in the litigation, they want the money. If you can settle and get a new law or get a statement of law or something else that might be most beneficial for the community, that's not what that person at the table would want as an outcome. So I have a lot of skepticism, but I'll leave it at that to start.
Yeah, very interesting. Thank you so much, Jan. But then I would also like to know a little bit to complete the perspective of what funders are doing. What are the cases? Because I know that in Lex Capital they also have been working with Padova University, right? Padova University, with the idea of trying to support human rights claims, right? So I would like to listen and to share.
Okay, I must introduce Lex Capital, which is a tiny company which was started last year, and we started last year in order to try to adapt the litigation funding tools to the Italian system, which is not very easy because justice is slow, cases are small, and so it is a kind of very, very strong war, because for us it's difficult to try to establish a model which may work. So we have a clear-cut idea. We are dividing and taking completely separate the for-profit sector and the not-for-profit sector. We decided to be since inception a benefit corporation, and we are working already just to answer the question of Carlotta on civil rights, particularly in the right of housing and in domestic violence. These are the two cases that we are looking after and we support, because they are very complex when you need to discuss them not at a domestic level, but you go to the United Nations level, and therefore the single person or the small company that needs to try to put on this case needs support. And we're trying to give them both financial support, but even more technical support, because we are able, because of the experience of the team and of the entire shareholdership, we are able to bring also expertise and network in terms of expertise in selection of experts and lawyers, specialized lawyers. So to answer to your question, we are start working on these two fields, on civil rights, and the second one we commissioned recently to the most important magazine in the no-profit Italian arena, that is called Vita, and is the most diffused newspaper and at the same time website, is a point of reference for the no-profit world. We commissioned a survey in order to get information on the needs of the no-profit organization all over Italy in the field of litigation and access to justice. Unfortunately, the survey is not available yet because it's ongoing these days, but we will make available as soon as the work will be ended in order to have a complete picture. We have been asking 10 questions to the non-profit organization to keep it simple, and it is these questions are all in the field of access to justice, time spent, and need of support in the field of litigation.
Thank you. I have like a new question, because after listening to you, and also I think that Yael's point is very interesting because it directly focuses on the conflict of interest that aim of profit may have in tension with access to justice, of course. But I would say, what about the solution given by Lex Capital, but also other associations or organizations like Peru, indeed, that they have a separate line like Access? If they are not really seeking for profit in that line, would the problem you stress disappear?
I'm not aware enough of the situation to answer that, but I can say that we work a lot with pro bono corporate law firms, for instance. In all of our cases, we can help, like Houthoff, for instance, and the Brouw and other law firms that support us fully pro bono on cases like ethnic profiling, the right to water for children in the Netherlands. That's awesome. I might have a lot of critique on the business models of these law firms, but the technical assistance that they give is great and is very valuable for, again, from the perspective of the movement and the community. That's my starting point. And if it's helpful for that, in the way, then sure. I'm like I said, I'm skeptical. I'm not against everything. We want to change. That's the main point.
Yeah, and we want to be skeptical at the beginning, of course.
Can I give us very small contribution?
Yeah, very small, and then we go to
very fast.
Just to be more specific, for the civil rights, we are raising dedicated funds, and we earn anything on that. We give it like pro bono. We go to charities, foundations, and ask for a small contribution. We support the work of the lawyers and the experts, but we don't charge anything. And for the non-profit organization, we are planning to do a different structure that is an evergreen fund, which is dedicated only to non-profit, and if we gain something, it's totally reinvested in non-profit. For non-profit.
Yeah, very interesting. Thank you. And also, Magdalena, now I would like to ask you, because I started with the idea of seeing cases in which eventually funders were supporting these good causes. So I would like you to share with us your experience from the US cases, and what can you tell us about those examples?
Okay, so I just wanted to make a little reservation.
Does it work in the mix? Sorry.
Hello?
Do you hear well?
Yes,
Okay.
I think you have to kind of hold it close to your
Yeah, probably.
mouth. So I'm not a US attorney, so I'm not an expert in terms of the US civil procedure, but I am a comparative lawyer and I function right now currently in the US reality. So I've got a few things to say. And one thing that I wanted to say before I start talking about the cases is this reflection that came to me. We are talking about private enforcement of law here, and we're sitting in Europe, and it's a monumental shift of the paradigm they were observing. The US has been kind of this source of I guess, experimentation, and that's where the private enforcement has flourished, and it has been actively encouraged by systemic design features in their civil law system and their civil procedures, such as the presence of juries, the allowance of lawyers to charge contingency fees and punitive damages and so on. We in Europe have been traditionally reliant on our public regulators and on public enforcement of the law. And now we are starting to realize that there's just not enough resources, there are not enough people, there's not enough time in a day, there's not enough money in our budgets to be able to do all this. There are certain violations of whether it's privacy rules or antitrust rules that just will not be pursued by public regulators. So we need private enforcement. So that's a reality that we're facing right now, and it's, I think this is the context in which we are functioning. But then looking back at the US, that's where private enforcement has been flourishing for many, many years, quite a few decades, and they've tried lots of things, and a lot of them have worked. And I think in the US, you can see definitely there is this, I can see that there's a division between, those cases that are funded purely for profit, whether it's by lawyers or third-party funders, which, by the way, third-party funding is really popular in the US. It is, until about 2 years ago, when the markets were really shaky, it was a major way to invest money, because you wouldn't get that much return on capital from your ordinary investments, shares or bonds. So investing in litigation, the return on capital could be up to 40% and more. So this is a very popular way of funding litigation, and the funding goes to law firms very often. Not all of them have those big war chests. Some of them need money, so then the funder will be supporting the law firms. But they also fund little cases, small cases, up to $2,000, for example. I know there is a Professor Joanna Shepherd at my university, Emory University, who's doing research into those cases where the small cases are funded by third-party litigation funders. So there's this one branch of litigation where we have for-profit litigation, where people are aiming to get a profit. But then there's the other branch, which I kind of think we're talking about here, which is public interest litigation. And here you have charities, non-profits. There are some, you've just mentioned one that you've worked with before we started this panel, but there are many others. There's, for example, our Children's Fund, who are funded by grants, membership fees, and just contributions from ordinary citizens. So they would be very active in their respective areas, and the Children's Fund was one of the major contributors financially to this very important environmental case, which was just concluded, temporarily because there will be an appeal, but it was a district court of Montana that has made a decision in the case. You probably all heard about it. It was discussed in the press. There was a bunch of teenagers, kids. The smallest one is a few years old, and I think the oldest one is like 22. It's called Held versus Montana, and it's an environmental law case. It's a fascinating case which was supported by one of these nonprofits, where the teenagers are suing the state of Montana for their very liberal, business-friendly policies on emissions and climate change. The interesting thing about Montana is that their constitution contains a clause within it which gives every Montanan the right to clean and healthful environment. So that was the legal basis for their claim. It was, by not taking into account things like emissions and things, you're awarding contracts to developers, to builders, to other businesses. You are violating our right to clean and healthful environment because you are contributing to greater pollution. Another really interesting thing about this case, and this, what kind of things this public interest litigation can lead to, there was actually a substantive discussion between scientists. They were being examined and grilled on evidence for whether pollution and man, activity contributes to climate change. And there was a 100-something page report that was written, and there is actually substantive evidence for all of you doubters out there, I don't know if there are any, that we do contribute to climate change. That's fundamental, because where else do you have this kind of quality and effort that gets put into a set of academic reports that actually will, produce evidence that we are causing climate change. So now we have a decision where the judge, widely criticized, of course, on the right, she was partial, and those teenagers, what are they thinking? But we have a judgment. So the state of Montana now has to revise some of their laws and revise some of their policies because of this decision. Now, of course, they are already saying that they will appeal, so there will probably be an appeal. But this is just one of many cases in that area, environmental law, where people are making a difference. And they're making a difference because we've got those nonprofits, those public interest cases. Then, so there's one. There's quite kind of funny cases of funding as well. I mean, the third-party funding is, like I said, very popular. I don't know if you guys know about this guy, Hulk Hogan. If you don't know about him, that's good. Okay, you're not missing much. He's a wrestler, and he's also an actor. At some point, he did something wrong with one of his friend's wives. And unfortunately, that was recorded on tape. And that tape was quite long, so about a few minutes from that tape were published on a website called Gawker. And anybody knows about Gawker. You might not know because, well, they went bankrupt. They're back online right now, Gawker.com. So Gawker published this video, and of course Hogan wasn't very happy about this. He wanted to sue. He didn't have the money. So he was helped by a third-party funder, which just happens to be Peter Thiel. Do we know who Peter Thiel is? Founder of PayPal? Obviously a very wealthy man who actually had a beef with Gawker because they outed him as being gay a few years back. So he helped Hulk Hogan bring that lawsuit. It was a lawsuit for about $100 million. So Hulk asked for $100 million, he got $140 million from the court. I think 25 in damages and the rest was punitive damages. That was reduced on appeal and then later they settled for about 30 or 40 million. Nevertheless, that lawsuit probably would never have come to the floor if it wasn't for a third-party litigation funder. So there's the serious stuff and there's the less serious stuff and everything in between.
And if I may, this also brings me to kind of the big question that we also posed at the beginning.